Sir, we have few questions in the chat box from the participants. I will read them out for you for the clarification, sir.
Sure.
So we have a question from one Mr. Satyendra. Sir, in the present times, artificial intelligence is also being used to develop vaccines, drug designs, identification of elements, space technology, etc. Since patent law is implemented elaboratively, that inventors are human. But what is the scope of AI-generated inventions to be protected as AI systems, as inventors?
I think the last
Sir,
set of my statements have answered this. AI can't be an inventor as of now in India. However, the law is evolving. South Africa has granted a patent to Davos. Australia, they consider AI to be an inventor. So there is a possibility of changing the law to adopt AI as an inventor because the involvement of AI has been increasingly used by enterprises, or AI has been developing several products. Like he said, drug discoveries earlier, it has been done by human beings, but now drug discoveries has been given to computer systems, and computer systems are coming up with radically with very speed. They are coming with the solutions. So AI required to be recognized as an inventor, but however, as on today, the law stands in India, AI is not an inventor. AI can't be protected, given as patent to AI.
Yes, sir. Sir, there is a follow-up from Mr. Satyendra, probably an elaboration on the question. So he says that if we consider the AI robots such as Sophia, which are constantly learning, enhancing, and are able to perform tasks independently, and is also being granted citizenship, if such AI robots make important inventions, would that protection in IP prevail to such AI robots in near future?
I think the answer is the same. However, what I say is we need to analyze the risk versus benefit. With the AI implementation, if there is some risk involved, how to mitigate that risk is what we need to first identify. That is a different thing. I think we are deviating from the main question of whether AI can be granted a patent or not. Certainly AI should, it is my belief that certainly AI should be granted a patent. However, the law stands as on today, it is not. AI will not be granted a patent today.
Thank you, sir. Sir, we have one more question from Mr. Samrat Bandopadhyay. Sir, if you are telling that in US they are giving patent based on effect and technical contribution, then how so many companies are filing for patent in USPTO on the basis of databases, data warehousing, data analytics, where it could be housed or embedded in hardware? Can you tell the position in EU and US, why so many companies are filing, on what grounds they are giving application for grant of patents with respect to softwares?
I think I've already discussed Inre Lowry case in USA. A memory structure is been attempted to file a patent application that has been refused. And both in US and Europe, in US it said that software which is attached to machine or software that transforms a particular thing to a different article, that can be patentable in USA. In Europe, it said that if it has a technical contribution or if it has a technical effect, then that can be patentable. In similar lines, in India, IPAB and Delhi High Court also said that if a software application has a technical effect or gives a technical contribution, then it can be patentable.
Thank you, sir. Sir, if the grounds is on risk assessment, on what grounds risk assessments in foreign jurisdiction is done?
This is a different, I think, AI systems, how it has to be developed. The law is still not matured enough. The law required to be, because whenever there is some incident happens, then legislators will think of how to fix that problem. So we are yet to be, we are at a stage of evolution of law on AI. There is no specific law has been designed around the world to control AI. So how AI need to be controlled, how risk need to be managed, there is no specific law as on today. However, countries are debating and coming up with guidelines and rules for AI implementation. In India, we don't have any specific law.
Yes, sir. Thank you, sir. Sir, there is a question which probably is relating to trade secret from one of the participants, Mr. Ritvik. Sir, did Coca-Cola or Pepsi disclose their secret formula while filing for a patent?
They have not filed patent. They have not disclosed their idea. Even till today, more than 100 years, Coca-Cola is selling the Coca-Cola drink, but we don't know what ingredients it is adding in it. So patents will be granted only when it is disclosed. As compared to trade secrets, you should keep it secret, whereas patents you need to disclose.
Yes, sir. Thank you, sir. Sir, with that, we come to an end of the Q&A session for today.
Thank you, sir. Thank you for inviting me for this session. Thank you.
Thank you. Pleasure. Thank you.